The story of how Oliver Wendell Holmes and Learned Hand evolved in their understanding of this question of the, the, the need for the state to prove the actual harm from the opposing speech that is being offered to state interests is told very well in a book by law professor Thomas Healy called The Great Dissent. He tells a story of how Oliver Wendell Holmes was on a vacation trip at the end of the term, traveling by train up the East Coast from Washington on his way to his summer cottage in Beverly, Massachusetts. As luck would have it, on the very same train, he encounters a very young district court judge, Learned Hand, who's on the very same train going up to Boston on his way to his vacation home in Cornish, New Hampshire. And Learned Hand, upon seeing the great Oliver Wendell Holmes, decides that it may be an opportunity for me to talk to him about what he had done in the Patterson case. Maybe there is a chance that I can persuade him that my view is the better way to decide in these cases. So he engages Holmes in conversation, and they begin to discuss the question of whether or not injury to the public welfare is the best way to approach shutting down speech that might be harmful to the government if the government says it's going to actually be harmful. And it's very clear from what Holmes is saying to Learned Hand that he is very much in favor of stopping this kind of speech because he sees it much like a death penalty decision. The government needs to be absolutely supported to be successful in war. The government cannot be undercut by any kind of a protest movement. And Learned Hand realizes he's not making any progress. And so he ends the conversation, and the two men part ways up in Massachusetts, going to their separate cottages. Hand really spends days and days thinking about this conversation and wondering why he was not able to persuade Holmes. And he figures out, this is the argument I should have made. And so he writes a long letter to Holmes. I encourage you to read this book. It's a wonderful book. And he says to Holmes, in my opinion, we cannot punish people just because of what they say. We have to have tolerance. He's not preaching the intolerance of the government and of Holmes. He's preaching tolerance. We need to at least listen to the views of the opposing individuals. We need to allow them to be tested in the marketplace of ideas. We need to see what the truth is by whichever side wins in this contest of ideas. And he says to Holmes, if they're wrong, by all means, punish them. But how do you know that they are not right? How do you know that they are not saints rather than the sinners you think they are? The only way we can have the marketplace of ideas and democracy to work is to allow for the tolerance of all speech and to see what the actual correct view is. Now, when he makes this argument to Holmes, there are a number of other people, a philosopher from England named Harold Laski, an eminent law professor from Harvard who would eventually be on the Supreme Court, Felix Frankfurter. They're making the same kind of argument to Holmes. They're trying to get Holmes to understand that sometimes the government claims interests in the name of the military, in the name of war, in the name of safety, that are maybe broader than need to be used, and the result is that they restrict free speech. In that kind of a situation, Holmes sees the first of the 1919 cases. And one of the things that was very helpful about Healy's book is he explains that the first of those cases is really not Schenck versus the United States. The first of those cases, he says, is a case called Baltzer, Baltzer versus United States in 1919. It is a case in which the government is punishing some individuals who are Mennonite in Wisconsin and who are objecting to the draft. The draft has been changed, and a certain number of young men from different groups have to be subject to the draft in every county in Wisconsin. But in this county, so many of the young men who were pacifists but believed in the government's effort to promote democracy and who had in fact enlisted in the military and were willing to fight, so many of them had already enlisted that there weren't enough young men to meet the quotas for the draft for that group in that county. And so they were asking for an exemption, and the government would not give them an exception. They were going to put people in jail for obstructing the war. And so the case was taken all the way to the Supreme Court. Should this county be subjected to the same quotas that all the other counties were, when in fact all of the eligible men who would have been drafted had already joined the war effort? Holmes, at the urging of Louis Brandeis, looked at what the government was saying and began to realize, maybe being influenced by Learned Hand's comments, maybe being influenced by the arguments of Felix Frankfurter and Harold Lasky, or maybe just his own understanding of what was happening in the war, he began to realize that maybe his view in 1907 in Patterson versus Colorado was not the correct view. Maybe he should make the government prove that there was in fact a harm to have this one county not be subject to the draft because they had already had so many young men enlist in the war effort. And so he came up with a different test. The test was no longer, is the action of this individual or group deemed contrary to the public welfare? He began to see this as a problem of the marketplace of ideas. And he said, I think that our intention to put out all our powers in aid of success in war should not hurry us into intolerance of opinions and speech that could not be imagined to do harm. He said, I am willing to err on the side of freedom. I'm going to allow for more tolerance of a different view. And so his new test was, the emergency would have to be very great before I could be persuaded that an appeal for political action through legal channels addressed to the government should be denied. I need to see that that emergency exists. Now, if this case doesn't sound familiar to you with all the reading that you've done in this area, it didn't sound familiar to me either. It's very hard to actually find this opinion. It's buried in Holmes's papers, because what happened is he wrote this opinion against the majority of the court that were willing to accept what the government was saying and put these people in jail. And Brandeis had already signed on to the opinion. And then Chief Justice Edward White made it clear that he was thinking of signing the opinion. And it was possible that another justice on the court was so persuaded by Holmes's view that he was going to sign the opinion. This opinion was on its way to becoming the majority view of the court. And that's when somehow the government found out that the Supreme Court was beginning to move in the direction of the protesters to the draft, and they withdrew the case. So the opinion never saw the light of day. But what it signaled to people who really knew what was going on in the court was that something was happening and the Patterson rule was in the process of changing. So the next of these cases is the familiar Schenck versus the United States. And this is a man who is passing out leaflets against the draft and telling people they should not make themselves subject to the draft. They should not join the war effort. And the question was whether or not that action was a violation of the Espionage Act of 1917. When Holmes looked at this case and realized that what the majority was going to do was the opposite of what they were going to do in the Balzer case, the majority was willing to uphold the government's view, uphold the draft, uphold the military effort. He decided to embed in his opinion an argument that would create the kind of possibility for tolerance of opposing views. He wanted to make it possible for the government to put Schenck in jail, but to also make an argument that maybe speech could be protected for other people if they could prove certain things. And the brilliance of what Holmes did is he separated the act of speaking and the result of that speech. He looked at the First Amendment and said, Congress shall make no law abridging freedom of speech, and decided that is exactly what I will uphold. Congress will make no law if it's just speech that's involved. But then he said, there might be situations where the results from that speech are what you can punish. You punish the actions, you don't punish the speech. So then we can debate about the link between the speech and the actions. And the image that he gives us is wonderful. You will often hear people say you can't shout fire in a theater. The link of shouting fire and what would happen in the theater, you can punish the results from that speech. But actually, the quotation is broader than that. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. You can't say something that is false. You can't shout fire in a crowded theater. You can't then cause a panic from what you have said. So we're looking at the circumstances and the degree of effect from the speech that result in the action. And now Holmes needs a rule that will tell us how close that bad action must be to the speech that might be false, that might cause that action. And his test is this. The question in every case is whether the words used are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. You've got to show that the nature and degree, the circumstances and effect of your words will result in a clear and present danger, whatever that means, that they will create a harm that Congress can regulate against. Show me how close the resulting harmful action is to the speech that is offered. That would have been very interesting if Holmes had actually used his test. You can also imagine what it would be. Watch what Schenck does. He hands out his leaflets, look at the line of people going into the draft, and see how many people walk away. See how many people do not subject themselves to the draft. Ask yourself how many people are like Schenck. Is this movement growing? Are there more people in other places around the country who are trying to obstruct the draft? Is there a clear and present danger of a substantive effect, that is, the diminishment of the drafting power of the military and the diminishment of the government's power to prosecute the war? Does it grow because of his speech? That would have been a useful opinion, but that's not what Holmes does. Holmes simply says, much like he did in Patterson versus Colorado, okay, I've separated speech and action. I've told you there's got to be a distance between speech and action. It's got to be a clear and present danger that results. But all I'm going to look at is this an emergency situation? He's using the test that he used in Balzer. Is this emergency great enough to allow the government to prosecute under the Espionage Act for this circulation of the draft protest? And he says yes. The answer is there is a great enough emergency. It's wartime. So all he's using to uphold the conviction of Schenck is it during war? If it's during war, then we're going to uphold the prosecution. The announcement of the test is promising for the protection of speech, but the use of the test is just as damaging as it has always been for speech. And that's the way the court continues to go in the next 1919 case. This case is called Froewerk versus United States. This involves a reporter in Missouri in a German-speaking magazine, German-language newspaper. He writes a series of long articles against the draft, talking about the history of the draft, the purpose of the draft, the working of the draft. He is then arrested under the Espionage Act of 1917 for undermining the draft, and the key precedent is Schenck. Holmes is writing the opinion. He's going to explain to us what his test means. Is there a clear and present danger of a substantive evil that Congress has a right to prevent? What he should do is look at how many people in that German-speaking area of Missouri didn't go into the draft, and how many of them read these articles. He's not going to look into why did the fellow write the articles. He's not going to ask, was he writing an article because it was a certain number of pennies per word? These were very long, almost academic articles about the draft. Was he intending to undermine the draft, or was he intending to inform about the draft? That means nothing to Holmes. Was there a link between what he wrote and the destruction of the draft? Again, that is not used by Holmes. He says, as far as I'm concerned, the fact that he wrote it tells us about his intent. It is argued that there is no sufficient allegation of intent, but intent to accomplish an object cannot be alleged more clearly than by stating that the parties conspired to accomplish it. They wrote the article, they edited the article, they published the article. That's enough for me. Now, what about the effect of the article? Holmes says, I don't need to say anything about the effect. I don't need to look at the effect on the draft. He said, on the record, it is impossible to say that it might not have been found that a circulation of the paper was in quarters where a little breath would be enough to kindle a flame that the fact was known and relied upon by those who sent the paper out. Just printing this was enough for the possibility of using a piece of flint and creating a spark on kindling that would destroy the draft, destroy the war effort, and destroy American democracy. I don't need to prove anything. The emergency is great because of the publication of these articles. Froewerk versus the United States. Holmes gets a chance to rework his theory in the next of the 1919 cases, Debs versus United States. Here, Eugene Debs, the leader of the Socialist Party, who ran for president many times, sometimes from jail. He did not win. You all know that. Eugene Debs was prosecuted for giving a speech before the Socialist Convention in St. Louis in April 1917. When he gave that speech, he knew there were U.S. Marshals in the audience looking to arrest him for opposing the war effort. He knew they wanted to prosecute him under the 1917 Espionage Act. He knew he would be the next case after Schenck and Froewerk. So he was very careful not to oppose the draft specifically in his words. Yes, he did make comments about the workings of the draft and the people in the audience. He said, "You need to know that you are fit for something better than slavery and cannon fodder." His words. And then he said, "Don't worry about the charge of treason to your masters, but be concerned about the treason that involves yourselves." Now, they all knew he was opposing the draft and their entrance into it, but he wasn't specifically saying that the draft is harmful. Don't be a part of it. But he was arrested. And here, when it gets to the Supreme Court, it's clear that what the court is looking at is not just what he said on that day in April 1917 in St. Louis about being cannon fodder and not working for your masters and being true to yourself. He had nearly a month earlier signed an anti-war, anti-draft proclamation by the socialists. And what the government said was, "We know what you believed when you signed that proclamation. When you said these words, that was in clear indication of your opposition to the draft." He's being prosecuted not for freedom of speech. He's being prosecuted for freedom of thought. And the thought he has is opposing the war and opposing the government. Holmes's version of clear and present danger will uphold that prosecution. And to do it, he needs to expand the power of the government over what they can charge using the clear and present danger test. He needs to basically show that the government needs to prove even less. That there is no doubt that there is a link between the clear and present danger and the speech that Eugene Debs has offered. So his version of clear and present danger now takes the version of intent of the speaker, of Debs, and puts it into a two-word, a one-word phrase with two letters. The word is if. Evidence that the defendant accepted this view opposing the draft, and this declaration of his duties at the time that he made his speech in evidence, that if in the speech he used words tending to obstruct the recruiting service, he meant that they should have that effect. If he said anything about the draft, it means he opposed the draft. It means he opposed, he was in favor of ignoring the draft. He's no longer worried about looking for the kindling that could spark a flame. He's saying that you look at the words of Debs and ask whether their natural tendency and reasonably probable effect will be to obstruct the recruiting service. You can assume that the speaker had his specific intent to accomplish that goal if you see a natural tendency and reasonably probable effect. You have no tolerance for what Debs has said. He's right back to where he was in Patterson versus Colorado. And now this story leads to the great descent of Oliver Wendell Holmes. At the end of these three cases, following the misfired case of the Balzer versus United States, we have the case of Abrams versus United States. It's the last of the 1919 cases. It involves an individual who's trying to get the workers in the United States to support the workers in the Bolshevik Revolution in Russia. And his solution is he is calling for these workers to go on a national strike. What he knows and what the government is going to prosecute him for, this time under the Sedition Act of 1918. It goes farther than what the Espionage Act said. It says you can't speak against, you can't conspire against, you can't organize against the overthrow of the government of the United States. You can't print anything against the overthrow of the government of the United States. When you look at Abrams versus United States, he's going to be prosecuted for asking workers to go on strike, with the government assuming if they do that, then they won't be able to build military machinery. They won't be able to fight the war in World War I. And this is where Holmes parts company with his 7 conservative colleagues, because he sees that Justice Clark is using his clear and present danger and the interpretations of the Debs and Froworks and Schenck case to say, I don't need to prove anything. He has printed this leaflet, the natural tendency and reasonably probable effect show me that there is an intent here to undermine the government and the war and the draft, to undermine the ability to win in World War I. It shows me that there could be a possibility of a dangerous harm. That was his intent. And Holmes decides it's time to adopt District Court Judge Learned Hand's view of a free marketplace of ideas. How do you know this is going to have that impact? You need to be more tolerant. We need to listen to protesters and wonder, are they correct or is the government correct? And what are we dealing with here? We're not dealing with an army of protesters. We're dealing with a poor and puny anonymity, not even enough to consider about what harm there would be. We need to look at this person as one of the protesters in a certain group in favor of the Bolshevik Revolution in Russia. And we need to understand that the government has always seen fighting faiths, people who are advocating for change in the government. But the only way you can deal with this is to allow for the operation of the free trade in ideas, as Holmes says it. He's using kind of an economic vision of a free marketplace of ideas. You put these views out there, you see whether people believe them, you see whether people follow them, you see whether that group expands in size. You see what the truth is. And Holmes, in one of the greatest dissents of all time, says you ask this question: more than just the clear and present danger of a substantive evil that Congress has a right to prevent. You allow for the possibility that the protesters may be right by adding the best test of truth is the power of the thought to get itself accepted in the competition of the marketplace. And he begins to argue that what you need to see is a closer connection between speech and the bad conduct. Clear and present danger isn't close enough. He starts talking about the words immediacy and the words imminent. I need to see a very close connection between speech and bad action. And so he argues, unless they so imminently threaten immediate interference with the lawful and pressing purposes of the law that an immediate check is required to save the country, he's not going to shut down that speech. So imminently threaten immediate interference. And then he adds, only the emergency that makes it immediately dangerous to leave the correction of evil, counsels to time, warrants making any exception to the sweeping command, Congress shall make no law abridging the freedom of speech. You need to see immediacy, you need to see immediate danger, and you need to see an immediate and imminent threat. That's when you shut down speech. This remarkable evolution of Oliver Wendell Holmes from where he was in 1907 in Paterson to where he was in the Balzer case and the Schenck case, where the government doesn't have to prove anything, to now say the government has the burden of proof to show there's an immediate bad harm to the society, to the military, to the war effort, linked directly to that speech. It becomes the groundwork, the foundation of the modern First Amendment. But remember, there's only 2 of them on the court who believe that, Holmes and Brandeis. And so our story continues with the cases following 1919.